Hi, my name is Caesar and welcome to Tips for Landlords and Property Managers brought to you by FastTV.com Law Group. Hi, welcome to another Tips for Landlords and Property Managers video. Today's topic, marijuana. Should California landlords allow tenants to smoke and grow it? Please remember, the contents of this video should not be considered legal advice. Please contact us for a free consultation. With many more states legalizing the use of medical and recreational marijuana as time goes by, it is without a doubt that the subject is presenting a new set of circumstances for landlords and property managers. There are state and federal laws in place regarding its use that can sometimes conflict with each other, which causes a bit of confusion. You also have arguments of rights such as your rights to allow or disallow its use on your property, the marijuana's user's rights, and the rights of your other tenants. As Bob Dylan puts it, all the times they are a-changin'. The fact is, whether you as a landlord personally approve or disapprove of the use of marijuana, you don't want to find yourself with outdated rental agreements that no longer meet their duties as property owners in the current legal environment. The bottom line is, there is no law in place at the time of the publishing of this video that requires landlords to allow marijuana smoking on their property. Tenants can consume cannabis on private property, but property owners and landlords may ban the use and possession of cannabis on their properties. The smoking of any substance such as cigarettes, cigars, vaping, or marijuana inside a rental unit can cause damages to walls, carpet, and other surfaces where odors can accumulate. Smoking of any kind can only be allowed if the landlord permits it. Whether you allow or disallow the use of marijuana in your rental unit, the wording in your rental agreement must be carefully spelled out. You should do it in a way that does not discriminate and in such a way that you can legally evict if need be. On the other hand, if you are going to allow it, make sure you carefully place limits according to Proposition 64. Things to keep in mind when allowing the use of recreational and medical marijuana in your rental unit. Landlords who allow the use of marijuana in some states like California, Colorado, and Washington have used it in the way they advertise their properties. This has rewarded said landlords with a wider tenant pool and higher above-market rental rates. It's important to remember that Proposition 64 has some limits on how much may be possessed or grown on a property for personal use, all of which need to be carefully addressed in the rental agreement. Be prepared to receive additional complaints from neighboring tenants. The most common types of complaints you'll get is odor and smoke entering their living space. Everyone has the right to the enjoyment of their living space, so it's important you have a strategy in place to take care of these types of issues. Things to keep in mind when disallowing the use of recreational and medical marijuana in your rental unit. First things first, rights and discrimination laws. Any wording you place in your rental agreement regarding the banning of cannabis should be carefully worded by an eviction lawyer. You'll also get a lot of medical marijuana concerns. Remember, there is no law in place that requires landlords to allow the smoking of recreational or medical marijuana on their property. Tenants often make the mistake of believing because it is legal, they are allowed to smoke wherever they want. There is nothing in the Americans with Disability Act that requires a medication to be smoked to allow a reasonable accommodation of a disability. Tenants can always turn to edible use of marijuana. Important: you shouldn't reject a prospective renter solely on the basis of cannabis use. This could be considered discrimination. Prop 64 allows growing plants of marijuana for recreational use. Marijuana can be grown indoors and outdoors, but the former usually requires modification to account for humidity, mold, ventilation, etc. The latter can become a tricky situation since Prop 64 doesn't allow it to be grown in public view. We mention this so that you as a landlord can keep it in mind. You can possibly address this in your rental agreement or make more routine inspections to make sure your tenant isn't heavily modifying your property. At the end of the day, the allowing of use and growth of recreational or medical marijuana under Prop 64 in California is ultimately up to you, the landlord. We hope the points covered in this video help you. If you have any additional questions, contact us for a free consultation. Thanks for watching. We'll see you on the next one.